This is the latest video from Right to Remain on understanding the UK's asylum and immigration system. Today's video is on understanding case law, and this video is going to be short. After speaking to members of the CARAG Asylum Support Group in Coventry, they were very clear. Anything more than 8 minutes, what are you even talking about? So short, sharp, and to the point today. So what is case law? Case law is the body of available writings that explain the verdicts of cases. So it's used to explain the meanings of laws, policy, or perhaps to establish the situation, for example, in your country of origin, in the case of country guidance cases. So they're other people's cases. They might be useful for your own case. Now, in an asylum and immigration case, there's certain kinds of ways that case law might be used to explain the situation. One of them is country guidance cases, or they might be case law that explain how cases should be decided, how a particular rule, immigration rule, or particular part of a law, what it means in practice. Because often when laws are drafted or written, it's not very clear in practice what that's going to mean. And sometimes it takes case law for judges to determine the Home Office should act in this way in this situation. There are asylum appeals that are chosen by the immigration tribunal. The tribunal decides that this is a good test case to give legal guidance for a particular country or a particular group of people in a particular country. And the decisions in these cases are assumed to be based on the best possible evidence about the country at that time. And until there are significant changes in that country, a country guidance decision sets out the law for other people seeking asylum from that country. So if we're looking at the example of Afghanistan, there's cases that look at women, Sikh women in Afghanistan. There's cases that look at Christians in Afghanistan, at whether people can relocate to Kabul if they're from another part of the country. And you can find the list of the most recent country guidance cases on this website that we link to from the Right to Remain Toolkit if you go to the After a Refusal page of the Right to Remain Toolkit. For country guidance cases, as we mentioned, on the judiciary website there's a list of the latest country guidance cases. You can try the Bailey website. So here it is. And if you know the name of the case, or most of the name of the case, you can put it in this search box here and have a look for it. The really important thing, though, is to remember to check it is the latest version of that case. So, for example, the person seeking asylum might have won the case at the upper tribunal, and it might be a helpful case for people seeking asylum from a particular country or people seeking the right to stay on human rights grounds. But then the Home Office decide to appeal it and get permission to appeal it at the Court of Appeal. If they win at the Court of Appeal, that Court of Appeal judgment is not going to be very helpful. But if you're trying to use the upper tribunal judgment, that's the previous judgment to prove your case, actually that's not the right law, that's not good law, but it's been overturned at the Court of Appeal. And then at the Court of Appeal, that might have been overturned, and at the Supreme Court, the person seeking asylum or other right to stay might have won. So again, if you looked and saw the Court of Appeal judgment and thought, oh, well, that's not very helpful, that's really negative, actually, it's possible there's a further judgment that is helpful. You might need to ask a friendly lawyer, even if they're not representing you, but just for information about which is the correct case to be looking at. When you find the written judgment of a case that you think might be useful, this is an example of the case called JB Jamaica. When you see the written judgment, you might see this at the top. This is what it looks like at the top of the piece of paper or the screen. And it's quite confusing. And so we've got a lot more information about this in our blog post on our legal blog called Understanding Case Law. At the top of the piece of paper or the screen, usually on the right hand side, you'll see a citation number, and this is how the case is referred to and found and categorised, catalogued. And it's a bit of a code, and we have information in that blog post about what the different codes mean. EWCA stands for England and Wales Court of Appeal. If you want to know more about the different courts, you can have a look at the courts page of the Right to Remain Toolkit. So you can look at that citation and that code for the name of the court to figure out whether this was the first time it was heard, or if, for example, it says the Supreme Court, you know that's it, because there's no court that's higher up than the Supreme Court. These court judgments can be really, really long. It is important to try and read it all, but there are often headlines which are either at the top of the document or the bottom of the document where the judge summarises what the decision is. These things are not always straightforward, and actually lawyers sometimes disagree about what particularly complex or important cases, what the impact is and how they can be used. So again, if you know a friendly lawyer, a law centre near you, where even if they can't take on your case, they might be able to just spend 5 or 10 minutes explaining what this case means, that could be really useful for you. Finally, just quickly on how to actually use these cases. If you've been refused by the Home Office or maybe First Tier Tribunal or even higher courts, these cases might be important. If they are helpful, if they describe a situation beneficial to you, that says, for example, actually the way you've described what might happen to you fits the pattern of what's happening in your country, that's really useful, and you can cite that, you can refer to that in a legal argument you make. It's important to note that cases might be useful for you even if they're referred to in a Home Office refusal letter as being negative, as saying, well actually this case says this, so therefore you don't need protection. You need to be careful. The Home Office cherry pick in their refusal letters. That means they decide which paragraphs of case law to use if they're useful for them, and actually there might be other paragraphs and the case in general actually might be useful for you, but you won't know that without having a look at the case. And a good way of finding useful case law is to look at your Home Office refusal letter, and they'll often refer to cases in that, and then you can search for those either using the Bailey website or just Google and read the case, read the whole case. Is there actually bits in there that are useful for you? Sometimes cases aren't useful for you. That could be because a country guidance case is quite old, out of date. Actually, things have got worse in your country or changed in your country. Therefore, you're going to need perhaps objective evidence, recent human rights reports or trusted journalistic coverage of the situation in your country. And there's more information about this on the After a Refusal page of the Right to Remain toolkit. It might be that the case describes a general pattern and that your situation doesn't fit that general pattern. Again, that's fine, but you're going to need to find evidence to show that despite the general situation being decided to be a certain way, maybe that your country is safe, your situation is different. You're going to need objective evidence, maybe even expert evidence, an expert report to back up your story. And there's more on all of this in the Right to Remain toolkit. And we'll put a link to the Understanding Case Law blog post with more information about this kind of thing in the description to this video.